window.
I have to look at the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a .3. When he gets over a .2 to .3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find, based on that, whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be. Some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both. In the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day, and that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance, so I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. Yes. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right? Any clarification or questions with regard to the state's rule or the court's ruling? No, defense? No, sir. All right, thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left, so I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay, all right. I need clarification, Mr. Owens, as to when the fifth amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that, when it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and let me get
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. Okay. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3. That would have been yesterday morning. Seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines?
Response.
I don't know the layout of 23, so
Can you all approach just for a second? All right, court's going to take a 15-minute recess to address jury selection location this afternoon, and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, if he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense?
She tested, but the test was negative.
Correct.
Is that correct?
That is correct.
Anything in addition to how she was feeling?
I read you what was provided to me.
I have no motion.
Okay. Court's going to be in a 15-minute recess. Thank you.
On behalf of the state, William J. for the state.
Defense.
James Owens from the script. Tony Henderson for Sarah Boone.
Ms. Boone is still seated at counsel's table wearing the same gray suit and white blouse from this morning. Can you all approach?
Date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay?
Response?
Is this going to be considered a separate hearing for the record? So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing, so I believe it should be pre-marked as D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve-out. What it has is what, and we were even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case in chief timeline. Count up as 80 photographs and videos. Attachments and rebuttal. Count up as 147 photographs and videos. There is metadata that comes with all those files. So there is a date stamp and time stamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? All right, that will received without objection as states 4.
So just to give the court an example, on page 49 of 59 of the PDF labeled Case in Chief, entry 31107 in this PDF from the phone extraction is labeled Videos, 2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline has a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020, culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him. So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there were problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of that child's friends. There was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we set. We believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd, 598 from the 2nd District Court of Appeal, decided in 2021. Lamb versus State, 246 Southern 3rd, 400 from the 4th District Court of Appeal, decided in 2018. Gale, G-A-Y-L-E versus State, 216 Southern 3rd, 656, 4th District Court of Appeal case as well from 2017. The basics of these three cases are just the very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Ms. Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone could be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the Confrontation Clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision, was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay and is not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of the things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of. Or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. I can't respond to you, I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those specifics, and then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you.
Thank you.
Response.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples of the photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity, that these are just boilerplate objections to all photographs, all video?
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce.
Correct.
It is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case. That's cause for me to speculate how it fits into their theory of the case. How can I do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case. Or a conversation that takes place between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, or they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? That's the thing well, I think the procedure goes like this. Yeah, I could be wrong, but I don't think so. The procedure goes like this. The state has a piece of evidence. They have that evidence identified to someone, all right? They get it marked as an exhibit. Okay, at a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence. Defense, either objection or no objection at that time. I've heard the witness who've identified it. I know what it is at that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say no objection? I don't know what they're using it for. Guess what, Judge? The videos of the suitcase, we didn't object to those. Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
Correct.
Sounds like it covers the suitcase video to me. All
No, it
means
doesn't.
all.
The suitcase video is listed in in the things that we don't object to.
I don't know that. I have image underscore 0954. I don't know what that is. Image underscore 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being omitted?
State conceded they need to lay the appropriate foundation.
Well,
It's part of their argument.
okay.
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do this in a criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last-minute issues. Then you all parachuted in on August the 30th.
Yes.
There was no order. There was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se, and to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As to foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections. But as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
We're just, I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden. And then Junella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works. This is my educational background, blah-bitty-blah-bitty with this software. And I pulled this extraction out. Mr. J sent me this carve-out of this extraction before trial. In fact, she picked it up yesterday. And I believe, you know, I'm going to testify that this is part of the larger carve-out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping for.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint for the ones that we didn't list the number and I didn't give detail as to like IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
Okay. I'm going to overrule your objections for the reasons that I previously identified. You can raise your objections at trial if you deem necessary. But based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation, and based on counsel's proffer, seems like they might be able to do so. Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
The state doing its proffer said there were no photos of the child. That's not correct. There are photos of the child.
That are being sought into evidence?
Yes, Your Honor.
State? Response, if any?
I don't believe so in either of the folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any. Okay, I see two images. I couldn't recognize it as a reflection of children in a, I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those two. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
Well,
I'm sorry,
it's an
Judge.
extraordinary file name, but I'm going to remove those two
Okay.
exhibits that they're
I
talking
take care of that issue for you, sir?
That takes care of that issue, Judge.
Okay.
But the point that I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know into what is the purpose of it as far as how is it relevant now. They can make a proffer. I understand they can make a proffer, but their proffer isn't evidence. Once it goes up, the witnesses and all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
Okay. All right, thank you very much.
Yes.
Anything else with regard to the defendant's objections to state's digital exhibits, Mr. Henderson?
No, Your Honor.
Okay. Moving now to the defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed. It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our panel?
That's fine.
All right, is that acceptable to the defense? Yes. Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return, and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you. Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Your Honor, most of them deal with just billings, observations by the medical personnel, so on, that don't necessarily apply to the issue of anxiety, as the court had indicated. I did include certain pages that discuss depression issues, as I believe that they were related to anxiety. And then I've identified 4 or 5 other pages that are not anxiety related, that may be relevant to the case. I've described that.
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15 pages, the first 2 that they list are pages 9 and 10 out of 111, and I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp, so I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22. 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there is a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least one medical doctor, well, 2. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the tox screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete.
But they are also seeking 49, correct?
Yes.
Thank you.
They just skipped 48, just like they skipped 26.
Okay.
Page 63, it appears to be repetitive, but we don't have any particular objection to page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018, so we don't object to that. So basically, we're asking for pages 26 and 48 to be included.
Okay, thank you. The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State, 369 Southern 3rd, 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records?
Judge, I did check with my secretary, Margaret, and my understanding is I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late, and I think it was yesterday or the day before, that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital, so we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may, real quickly, based on the invoice that was sent from the Winter Park Advent's billing department, apparently it's a separate subcontractor, the request would be on the 27th of September. I suspect they waited until they received confirmation of payment of $135 for the receipt of those, so we received those. So it's all been within a couple of weeks, plus we had the hurricane issue last week, and so I think there were issues as to the matter being provided for. I did speak with the state yesterday afternoon after I had a chance to look at the records, and I had some sense of what these matters were in relationship to, and was told that they already had those records and familiar with them. So I don't think there was any prejudice to the state based on our submissions.
Okay. Any further argument or positions with regard to the Richardson analysis, Mr. J?
That's for the purpose of this hearing, I'd like this stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Your Honor, there was just a reference that the 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes, sir.
entered as 1, correct?
Yes, sir. It is sub-labeled within these records as page 2 of 14, and it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that, and so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I have not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, you know, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance of those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide any
Okay.
information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed, so they closed. So we were there at 8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand to state.
Okay. Appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages 26 and 49 as, 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that are sought to be moved into evidence with regard to this January 23, 2018 incident, as provided in the 119 pages of item 2 of the defendant's Fifth Amended Reciprocal Discovery Exhibit List. I will not foreclose the state regarding page 68 of the 81 pages. If they are able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, yeah, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force.
I'm not discussing the jury instructions at this time.
There are evidence of prior threats, of prior events of violence committed under that instruction, under the self-defense justifiable use.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did pull up a couple of these on the justifiable use of non-deadly force.
That does not answer my question.
I would agree not to use those.
Okay.
The two I'm interested in using and opening is this standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering the verdict. You want me to read it out?
No, I can see it, sir.
And then the other one is a reasonable doubt is not in there. Possible doubt, speculative, imaginary, or forced doubt is the standard instruction on using it.
What's your position with regard to those two, Mr. J?
Judge, it's opening statements. We should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards at opening statements I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started, and then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions in limine, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or, if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as it, I mean, we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from when
Give me a moment. That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law. When we're just talking about opening remarks, 6 through 10 are optional. We haven't decided which out of the optional instructions, 6 through 10, we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law. You know, that in many ways, we do it where we give them the law at the very end, you know, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
And I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
We know that
aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
yes,
Yes, sir.
Judge, the standard is it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established, and that self-defense must be established by the testimony, and in this particular case it has to come from the defendant, of an overt act taken by the decedent which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet, from the defendant, and certainly A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not a lot of dispute over whether that will come in if we meet that standard of an imminent act or an overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things. If we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. It's, I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, Judge, absolutely, at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, it was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that prior?
No, what I ruled is that you were able to discuss them, you address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse syndrome. I said self-defense. These exhibits come in under self-defense. In arguing these, I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior difficulties, prior acts of violence is a standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there is going to be evidence of an overt act. That she was facing imminent threat, and she reacted based on that threat.
Understood. Your response to Exhibit B?
Now, if I look at B, which one's B?
It's her on the back porch with the two dogs.
Judge, not only did he abuse, George Torres abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is a part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want to introduce that they listed as exhibits. I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, George Torres, he abused the dogs. And he would threaten to abuse the dogs to control Sarah Boone.
Okay. Thank you.
They're checking, Judge,
All right.
on whether they have all
The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, the purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be pasted back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific, some incidences may have happened, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
it.
Defense.
No, sir.
All right. Are we prepared to bring in our jury at this time?
I've got two other issues.
They've been waiting for an hour and 20 minutes, Counselor.
We intend to play the 2-minute suitcase video to the jury in opening statement.
State.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
What's the other issue, sir?
I need to approach eventually.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. What's good for the goose is good for the gander. If not going to allow your photographs, not going to allow the state to do anything. You could orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start dismantling?
Please, I would appreciate it. Thank you. All right, thank you both for your honesty. I appreciate that. It's something we talked about earlier this week. That's the one thing that we required and asked of you, is just to be open and honest, and I appreciate both of y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that it would impacted you or influenced you in any way, to have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. Jay, you may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. The evidence is going to show George Torres is dead because in this defendant's judgment, he deserved it. And out of a conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah. The defendant will say, "For everything you've done to me." Sarah. "For everything you've done to me." Sarah. "Fuck you." And then the defendant laughs. Sarah. "Fuck you." And the defendant laughs. Sarah. "Stupid." Sarah. "That's my name. Don't wear it out." Sarah. "I can't fucking breathe, baby. Seriously." "Yeah. That's what you do when you choke me." Sarah. 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 The defendant laughs again. Sarah, I can't breathe, babe. She laughs again. That's on you. Sarah, I can't breathe. She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up. Sarah, shh, is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound George Torres gets put into this suitcase, left to die? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere, just Torres, and eventually realizes, oh my God, he's in the suitcase. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, he took his little legs out. At some point she makes that statement. And tries to resuscitate him. Hears gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out and gurgling. Then the next thing she does is she doesn't call 911. She calls Brian Boone. Who's Brian Boone? Well, Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. A normal work day for most people. School day for their child that they share in common. But after they got divorced, the arrangement was every other weekend, they'll co-parent. And that weekend included Friday, Saturday, Sunday. So it's that 3 schedule. And then Mondays and Tuesdays, their child would be her responsibility, and Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility. So February 23rd, 2020 was a Sunday, and now we've led into Monday, February 24th, 2020. Mr. Boone had been trying, actually, to contact the defendant several times that morning, because he just wanted to confirm she was going to get their child after school that day. And there had been a history of reliability issues on that issue on her part. So you will see in the phone record, he calls her and calls her and calls her. And then she finally calls him back instead of calling 911. And being the nice co-parent that he is, he comes over. It's a short drive, 5 to 10 minutes. And as she's explaining to him what the heck is going on, he peeks in through the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right, but there's a doorway that you can see all the way through. And on the back side of the kitchen in the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, "Check, please." You need to call 911. He doesn't set foot into that townhouse. He does wait outside, though, being the good co-parent that he has been. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call. What you will not hear are tears. You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide-and-seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase, and I fell asleep. He's not awake. He's purple. He's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in suspicious deaths, was taken to the 9th District Medical Examiner's office and autopsy. What the doctor found was what you would expect after being left in a suitcase, crumpled up in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breaths when you're crumpled up like an accordion, and environmental suffocation. You don't have to have a plastic bag over your head, taped shut with a full roll of duct tape to seal it off 100% and be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, he suffered from blunt force trauma on his torso, in his face, his mouth. She'll use words like contusion. Will help her explain contusions and bruises. She'll use words like hematomas. Will help her understand for you all that that means bleeding under the skin and blood. What you expect from a bruise, that's why they're running through. But he had all this additional trauma. He had trauma on his fingers as well. So now, the sheriff's office, Orange County Fire Rescue show up, and the defendant interacts with the first patrol officer. You will see and hear that body-worn camera. And it's more of the same of what we heard on the 911 call. Hide and seek. It was good. I fell asleep. I don't know what happened. A few hours later, the detectives from the homicide unit at the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone, off of a counter that was found out of a suitcase in Mr. Boles, and giving it to one of their digital forensic examiners, who we'll hear from later in the trial, But it's time to give a first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over from Boer wasn't even half full, so the description she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are 750s, 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, so the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are in fact Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine but were not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoked, did art, listened to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th and 25th. What they are doing, and by they I mean the Orange County Sheriff's Office in part, is going through her phone. That's when they discovered the 2 videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, we've been good. I've been good. She describes that he comes at her all the time. He comes at me, So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before, though she described it happening before. I'll never drink alcohol again. She insists that she has no injuries on her, and you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres' brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Ms. Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces and nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote-unquote dad hit me in the face. The next text is, hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too, I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres, referring to Mr. Torres, getting rid of. And that's the case. That's what the evidence is going to show. But we, the state of Florida, and the members of the jury in our journey through this case, we're all going to come up to a door that says, danger, keep out, stay away, by court order. And that door says, the defendant's history with the victim. It is a door we shall not enter without permission and invitation. Halloween is in like 13 days. Part of the vampire lore is vampires can't come get you in your own house. Well, I anticipate during this trial, we're going to be invited in to the defendant's past relationship for the previous couple of years with Mr. Torres. And as we come inside this room, at her beckoning, we are going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she'd ever been punched, I expect the testimony will be. And he made her curl up in a fetal position on her own porch for 4 hours, and she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 342 once when he got treated at the hospital. This is a man who had serious alcohol problems, and I expect you're going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with a relationship that make it harder to break off a relationship, it's one thing to have a bad first date. It's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now, these dates are at bars, and there's nothing wrong with that. And it just typically ends up, she's going to tell you, I suspect, or you're going to hear that she said, one way or another. It's one thing or the other. Like, I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. And you're going to hear and potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes, cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview happening about a month before this. Bloody ear, a stab wound in the leg, which is perhaps described as sword fighting, playing around in medical evidence. But nonetheless, I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this comes in, the state is going to have the opportunity to take lead of the tour in this room, labeled the defendant and the victim's past history. And I'm not going to go into that now. If this all comes to fruit, the blooms on the tree during the trial, we'll discuss it at the end where it's more appropriate. But I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on February 23rd. Now, like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance you may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. It's well recognized. The experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called the DSM-5-ER. Diagnostic Statistical Manual, version 5, and I think it's text revision or something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis. It'll say, well, all of us agree that it means these three elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. Gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between experts, because it's kind of like grandma's recipe handed down from generation to generation without being right. But what I expect you'll hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over on an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well by the defendant, perpetrated on her by the decedent. You'll hear about all this. And what it ties into at the end of the day, after we talked about this during jury selection, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society, but years ago when this was first being researched, the question would be, well, why don't you leave? And battered spouse syndrome and the testimony from these experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, the isolation, control, so on and so forth. And that explains why you wouldn't leave. Well, now, but turning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions if you get a self-defense instruction as part of that. That's what it's used for. It's not used for explaining the subjective beliefs that one holds. What you will also hear about these things is, just like any other doctor or any expert, like a home inspector. If a home inspector's report was based solely on the person who's trying to sell the house, what they say about the house, great shape. I rewired the entire thing. Brand new JDC pipes. This sucker's good to go. I'm great with it, $600,000. You're not going to take that home inspector's report unless they lift the hood, take the tires, do all the things that the Fox on here, the Carfax does. You want an expert to get reliable information. And an expert's opinion is only as good as the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the person who's giving you the story, even if it's the patient or the client that is saying all these things happening to her. You got to find corroborative information. You got to check reliability, particularly in circumstances that we discussed. So another thing that they're going to tell you is just because there's a bunch of violent nonsense going on between two intimate partners doesn't mean that spouse syndrome applies. Some people can go home and fight like cats and dogs. And that's just their day, and they get over it. They live their life and fight another day. Their cycle just spins like that. So just because you hear about those things, what the experts will tell you, it doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Harper will say that it applies to Ms. Boone. But we'll talk to her about what she relied upon to make that conclusion. We'll talk to her about some other things and take that journey together to get there. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth to the video, where you don't have to rely upon the credibility of anything other than your own two eyes and your own two ears, the state admits that you're going to return a guilty verdict for second-degree murder. What the evidence is going to show is that the defendant killed Mr. Torres because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances needed to. Thank you.
Thank you, Mr. J. Any opening remarks by the defense?
Judge, could we invoke the rule if it has been?
I've already advised the witnesses.
Okay. The rule of sequestration will be invoked. Thank you. You may proceed, sir.
Ladies and gentlemen, good morning. Appreciate y'all being here. I was introduced before. My name is James Owens, and I represent Sarah Boone, along with Tony Henderson and Kevin Beck. Now, this is going to be a several-day trial. Obviously, today, Monday, Tuesday, Wednesday, we're not sure, but we're trying to make arrangements for witnesses to fly in, expert witnesses and whatnot, and we'll know more probably end of the day or Monday, so you can plan. But I know your focus is on this case because you took a note to do so. Ladies and gentlemen, there is no higher call than to write a will. No higher call than to write a will. And we're going to ask you to write the story. And find Sarah Boone not guilty because she was justified in the force that she used to defend herself. If that force was reasonable under the circumstances that existed between Sarah Boone and George Torres. Sarah Boone and George Torres were down and out, as you can be. Their life centered around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years. And there were several prior incidences of bodies. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. And considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that. All the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon. And they come out with one of those larger bottles of the wine. And then, of course, there's a receipt. And the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, is what this is about. How are disagreements resolved? But George was very jealous of Sarah. And you're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her. They bought the wine. It's a simple life. They don't have much money. But they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to the Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in and going out, and there'll be a receipt for the purchase of that bottle, and then there'll be that bottle will be in the garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows. This is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle, or she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it. And that's how they move it back and forth. Well, as she comes down the steps, she sees him getting in and settling in the suitcase. So she walks over there, and they see each other, they smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch, and at some point he says, "I can't breathe." Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get out. He has to sit and listen. It's a unique form of physical restraint. And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, the suitcase is flipped upside down. The zipper's on the bottom. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, "Sarah." And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from George Torres, which the law acknowledges that every one of us has a right to invoke, the right of self-defense. You can hear from the medical examiner. She is going to tell you about some bruising on George Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain. But there's some bruising. Sarah's going to explain that to you. Why that happened. What were the circumstances surrounding that? Involving a bat. Her son comes and stays with them from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that George Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate. Sarah loved George. You know, you're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles. Sarah had no intent to kill. The prosecutor mentioned she wanted him to die. Farthest from the truth. She loved her man. She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak. Vulnerable. You're going to hear it all. You've got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect. And, you know, she goes, as many of us do when we drink too much, you know, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. Thought he was on the computer looking for a job. She looked outside. Maybe he's out smoking a cigarette. And she sees the suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house, where her son is at, Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian, look, what do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. And she called 911. She calls 911 within a minute, two. Detective Rodriguez arrives. They got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible. Eventually, she gives a statement to law enforcement. She gives one to Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And they know what to do. They try to assess the situation. They start putting the tape out. And then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. You may hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it and take out all the data, all your phone calls, text messages, photographs, videos, all that. And they find these two videos. Sarah's not aware, she doesn't remember making the video. You can imagine. She gives them the phone. Of course, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Copsall is her name, Chelsea Copsall. And they end up, Deputy Copsall was pregnant. Or Detective Copsall was pregnant. Said, end up, hey, we're not going to bring your phone. I'm not feeling good. I'm pregnant. Can you come to the sheriff's department? Which Sarah Boone was to tell you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead, it was an interrogation. And they were going to arrest her. They made their mind up already. And they were going to confront her and try to get her to confess based on the two videotapes. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon when she got there to get her phone. They said, well, we got to come up here. We need to talk to you. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used. She doesn't. I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking the stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you and read an instruction on evaluating a witness's credibility. And they'll talk about corroborative evidence, other evidence that's consistent with the testimony that Sarah Boone did. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional. Self-defense nonetheless. Now, as I said, the struggles that occurred, many of them involved the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. The police are there. So her attitude is not one of distress. We're here today, full packed courtroom. Judge Cranit's here, but you're the most important people. Because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush to judgment, to keep an open mind, and understand there's two sides to this case. There's their side and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in jury selection. That's extremely hard to do. Now you're going to hear some testimony. There's been mention of experts. Battered women's experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty. Because it's the right thing to do. Thank you.
Thank you, sir. Can the parties approach for a moment? Good morning. You could be seated. And once seated, if you'd state and spell your name for the record for us, please.
Juan Torres, Juantorres.
Thank you, sir. You may inquire, Mr. Cacciatore.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
6 or 7.
And how long has your family resided here in the Central Florida area?
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. In Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we would talk, I'd say, on a weekly basis.
And how far away did you live from George?
About 5-10 minutes. Pretty close.
Would you see him pretty often?
I would try not to go over there too much.
Who was George living with at the time that he passed away?
Sarah.
And without getting into many details, what was your relationship like with Sarah?
We didn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
We were just talking like we normally did. He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
And you recognized her voice?
Yes, sir.
What was she yelling about?
Something about choking or how he choked her. I really don't. That was it.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background, so that was it.
Did she sound upset?
She sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Have you ever spoken to Sarah since that conversation?
No.
I have no further questions.
Any cross-examination?
Good morning.
In the beginning, when you started, it was hard for me to hear, but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother George Torres, did he ever stay with you at any time?
No.
Would he ever live with you or any of, I mean, not you, but any of your other siblings?
No.
All right, sir. Let's go back to this phone call that you were talking about that was on February 23rd of 2020, and that phone call was approximately 7:30. Is that correct?
Yes, sir.
All right. And who called who?
He called me.
And then y'all were talking. Is that correct?
Sir.
All right. And when he called you, did you notice anything about his speech or his voice?
No, he was fine.
Sounded normal?
Yes, sir.
Okay. So he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No. Because I knew when he would drink.
Okay. So in your opinion at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
Now, you said you heard Sarah.
Yes, sir.
Is that correct? How did you know it was Sarah?
I can tell in her voice.
You recognized her voice. So you could hear her. Is that correct?
Yes.
All right. And you've heard Sarah speak before that time. Is that correct?
Yes.
And you've heard her speak on the phone before that time. Is that correct?
Yes.
And you said that Sarah was yelling. Is that correct, sir?
Yes.
And she was yelling about, he's choking me. Or tell him about choking me.
Yes.
Okay. During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
Not really.
You've heard it before?
No.
Based on Sarah's voice that you've heard, was it any indication to you that she had been drinking?
No.
No? Sir, at some point your brother said he had to go, is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have, if I can confirm.
You may, sir.
Sir, other than siblings, do your Your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
Thank you, sir. No further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You're released subject to recall by either party. Thank you.
State would call Devin Jamro.
Sir, good morning. You could take a seat and please state and spell your name for the record.
My name is Devin Jamro. That's Devinjamro.
Thank you. You may inquire, sir.
Sir, who do you work for?
I work for Public Supermarkets.
And what is your position with public supermarkets?
I am the assistant store manager.
And at what location?
Currently the Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
Your Honor, may I approach the witness which has been previously marked for identification as States D and been shown to defense?
D is in Delta?
D is in Delta.
Yes, you may.
Sir, I'm showing you it's been marked for identification as States D. Could you use these scissors and open this and look at the contents of this package to yourself?
Sure.
Sir, do you recognize those items?
I do, yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly and accurately appear to be the receipts from your Publix store?
Yep. Yeah.
Your Honor, at this time I'd like to move what's previously been marked for identification as States D into evidence.
Any objections?
No objection?
What was pre-marked as States D will be received into evidence without objection as States 1.
Your Honor, may I approach the witness who's been previously marked for identification as States J and shown to defense?
You may.
Sir, I'm showing you it's been marked for identification as States J. Can you take a look at that disc?
Yes,
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did, yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes,
And in the normal course of business, are the videos from those surveillance cameras kept?
yes,
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
yes,
And they fairly and accurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
they do, yes.
Your Honor, at this time I'd like to move what's previously been marked for identification, as states J, into evidence.
Any objections?
No objection.
What was pre-marked as states J will be received into evidence without objection as states 2.
And I have no further questions for this witness.
Any cross-examination? Can this witness be released?
Yes.
Thank you, sir. You're released.
Thank you.
Have a great day. State, you may call your next witness.
State would call Joan Williams.
Ma'am, good morning. Could you state and spell your name for the record for us?
Okay, Joan, Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker at Orange County Sheriff's Office.
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for an emergency, non-emergency, medical, which I transfer to the medical side of the business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Yes.
And those records are made at or near the time of each call, correct?
Yes.
Your Honor, may I approach the witness which has been previously marked for identification as states L and been shown to defense?
You may.
Ma'am, I'm showing you what's been previously marked for identification as states L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time I'd like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
It was pre-marked as states L will be received with no objection as states 3.
Your Honor, I have no further questions.
Any cross-examination?
No, sir.
Can this witness be released?
Yes, Your Honor.
Yes.
Thank you, ma'am. parties approach momentarily. State, you may call your next witness.
State will call Vincent Battaglia.
Raise your right hand to be sworn. Please be swear or affirm that the testimony you give shall be the truth, whole truth, and nothing but the truth, so help you God.
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
Thank you. Sir, you may inquire.
Good morning, sir.
Good morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Them.
That's Brandon Motes?
Yes.
Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and George Torres?
Yes.
And approximately how long were you neighbors with them?
About a year, a little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And I believe you tuned a guitar for a child there at the house?
Yeah.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time
It was
was this?
pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, like probably 4 to 5 months before that.
So 4 or 5 months before February of 2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like, if I do hear anything, like through the walls or whatever, as out back, just kind of keep my mouth shut. Like, don't really speak about it or anything like that, or say anything to anyone. And I just was like, okay.
Did she make any motions with her hands?
Yeah, like just kind of like, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
So she told you not to report anything you may have heard about arguments or yelling or fighting, anything going on over there?
Yeah.
Do you recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake and it stopped me mid-conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
Did you hear any yelling coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Could you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing. At the time, that's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres's voice?
Yeah. All the time. It was like a back and forth. Yeah.
So other than the statements and the phrases of I hate you, you weren't able to discern the contents of this argument?
No.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, Then it was just like a loud rumbling noise, like that literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor, like all around, very thin walls.
Now, was your bedroom, where was it located in your apartment?
The back of the apartment, so it was like there's like a little kick out next to my patio, and that's like that was my bedroom back there, like along the grass back there.
On the first floor?
On the first floor, yeah.
I have no further questions.
Okay.
Any cross-examination?
Mr. Cagley, good morning.
Good morning.
Now, you said that you lived there next to Sarah Boone and George Torres for about a year?
Yes, sir.
Are you aware that the police were called to their residence?
Like
While you were there for the year, are you aware of any incident in which the police were called to their residence?
I had never seen anybody there, but I had had other neighbors in the complex tell me that it has been on multiple occasions. So that's why.
Just instead of what somebody else told you,
Yeah.
just what you would observe. Did you ever, the year that you were there living next to them,
Yeah.
were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
All right. And did you work odd hours or? You went
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Do you have an opinion as to whether or not, based on your interaction with Sarah Boone?
I'm going to object.
Let me finish the question first, please.
Do you know, from your experience with Sarah Boone and your experience with George Torres, that they drank alcohol?
Yeah.
Hang on.
I'll withdraw to that question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you.
Yes, sir, of course.
Well, Vincent, I think you had testified, you may have given a statement to law enforcement,
Yes, it was one of the detectives.
a recorded statement?
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time, yeah.
I believe you had said that,
I'm going to object as to improper impeachment.
Approach. Objection's overruled for now.
sir, would it be fair to say on that date you got home around 7? 7 p.m.?
7 p.m.?
Yes.
Which day was this?
Sunday, February 23rd, 2020.
No, that day I actually got home from work probably around 1 or 2 o'clock or so.
In the morning?
No, in the afternoon. Because I went to work that morning at around 5 a.m.
And you said that you heard the normal yelling and arguing at about that time when you got home?
No, it was around that time, but it was really around like 10 o'clock, 10:30 is when like the arguing I could really hear clearly. It was like around 10:30 at night.
Okay. Thank you. Thank you.
Any redirect?
Just very briefly.
Yes, sir.
So on cross-examination, you were asked about the arguing you heard, and I believe your testimony was that it was pretty intense around 10:30.
Yeah.
Approximately what time was it that you heard this loud crashing thump sound that you described?
Little after that.
Overruled.
It was a little after that arguing and stuff. It was probably around 11:15, probably 30, 45 minutes after like the arguing I could hear started.
No other questions?
Can this witness be released?
Yes, Your Honor.
Not subject to recall.
We would like him subject to recall. You've got his number.
Okay.
Your Honor, may we approach?
Yes.